Good morning. I hope you're all there having a wonderful Saturday. This is Immigration Attorney Peter Loblack. Today we're going to discuss generally U.S. immigration issues, but I would like to concentrate with an emphasis here on removal of conditions, and that is removal of green card conditions. As you know, my offices are located in Florida. The telephone number where you could reach me directly in my law office is 407-295-0099. Again, my name is Peter Loblack. I'm a licensed attorney in the state of Florida. I have offices in both South Florida and Central Florida, Orlando, where we are today. I have received a number of questions, and to follow up on our last discussion and the last video, which dealt with marriage-based green card. The next step is the removal of condition. Generally, when individuals are married, you're married to a U.S. citizen or you're married to a green card holder, you apply for adjustment of status or you apply for an immigrant visa. If you're successful, you obtain the immigrant visa, and that is really the green card. And the expiration date for most of you would be 2 years. And the reason for 2 years green card, when it's based on marriage, it is to determine whether the marriage is bona fide. Even though you have gotten that green card, initially it's called conditional green card. So 90 days prior to the expiration of that 2 year, you and your spouse are supposed to file a joint petition to remove the condition. And that is done on an I-751. It is not simply filling out that form and sending it in. You need to provide bona fides of the marriage. And when we say bona fides of the marriage, from the last discussion on marriage-based green card, you need to provide documentary evidence that your marriage is a bona fide marriage, and that comes from the documents from the date that you obtain the conditional green card. Not information and document prior to obtaining that conditional green card, because you provided those documents already when you got that conditional green card. Now, the conditional green card is granted if it's issued 2 years, or strike that. The conditional green card is granted if it's approved within 2 years of the date of your marriage. So that's crucial. If you do your interviews and your card is approved 2 years prior to your marriage, you will get a conditional green card. And that means you and your spouse will have to file a 751 to remove the condition and to provide documentary evidence. If you have substantial evidence and you file a joint petition, and you have substantial evidence that your marriage is a bona fide marriage, then you may get the green card in the mail. You may get a request for additional evidence, and everything work out, you'll get the 10-year card in the mail. Now, the question is, why can't I just get the card in the mail? Do I have to go to an interview? And the issue always comes out when you're facing removing the condition, do I need a lawyer? And that, in immigration, at most junctures, people are going to ask, do I really need a lawyer? Can I just do this on my own? Yes, you can. You could do anything, as I always say, on your own. But if you truly want to get that conditional card removed, the condition on your card removed, and to get that card, the 10-year card, it is advisable, I always say, to use a lawyer. Generally, if they have no children of the marriage, that could be an issue. You may want to use a lawyer. If you do not have substantial evidence, bona fide evidence of you have shared your life together with that spouse over the 2 year period, it is wise to use an immigration attorney. Now, would an immigration attorney guarantee you're going to get the card? No lawyer guarantees that you're going to get a card. It is based on the evidence, and your lawyer is going to help you provide the evidence and provide documentation you may not even think that is relevant to your case, that is relevant to approval, it is relevant to a bona fide marriage. So it is wise to do that, because the more evidence you could submit with the 751, the better it is. So I would advise everyone generally to, if you can, and use a lawyer. It is just the best thing to do. Now, you have an option of the marriage is still intact and you're filing jointly with your spouse. That's one situation. However, though, and the majority of issues and questions come in, we have separated. My spouse, the U.S. citizen, and I have broken up. Maybe there was infidelity in the marriage. Maybe there was discord. Maybe the person figured they do not want to continue with the process for one reason or another, and the issue comes up, can I still remove the condition of that on that card? Before we even touch that, I want you to understand, if the removal of condition is denied, you will be placed in removal. Removal is deportation. And that involves a separate set of situation and circumstance that you'll have to deal with before the immigration judge. But if your condition is denied, removal of condition is denied, the law says you will be placed in removal. Also, you cannot adjust your status through any other means. You just can't. You have a conditional green card. The only way to get a permanent green card is to remove the condition. There are options. If the condition is terminated, we will address those issues later on. There are some issues under the law that maybe you could remarry, but a determination has to be made that you no longer have a green card, because once you have a green card, you cannot apply for another green card, and removing the condition. And removing the condition is indeed a green card. You have your conditional green card. For all practical purposes, it is a green card. Whether it's a 2-year card, it's a 10-year card, it is a green card. So there are issues that you're going to deal with. So your wife or your husband have left, and you cannot, and you now faced with trying to remove the condition. You're within the 90 days period of the expiration of the card. What can you do? Well, if you look at the form, the 751, it provides an opportunity to apply for a waiver. And the waiver is waiving the joint filing of the petition. And the 4 areas that you could check off. 1, the marriage was a bona fide marriage and it ended in divorce. So that's one option you could apply for a waiver on. The marriage was a bona fide marriage, or you suffered battery or extreme emotional abuse by your spouse. That's another one. And the other one that a deportation would be an extreme hardship to you. We'll discuss that. And also, maybe your spouse has passed away within the 2 years and you cannot file a joint condition. So these are the situations that you're going to face. These are the conditions that you will face when you deal with it. So let's deal with the most prevalent one, the marriage and then divorce. You understand, though, that there's no condition to check off that you just separated. So you either have to divorce, or you suffer battery, your spouse has passed away, or a deportation would be an extreme hardship to you. So if you're separated, there was no battery, then the issue is a divorce. So if your marriage was a good faith marriage, and you will have documentation to prove that the marriage was a bona fide marriage at inception. So we need evidence to substantiate the bona fides of the marriage. But you need a divorce. If you don't have a divorce, there's no battery, then one would have to make out a case that your deportation would be an extreme hardship to you, and that is maybe one of the most difficult waivers to get, because we have to substantiate what happened within the 2 years that would cause a deportation to be a hardship to you, and not require substantive evidence to prove. For most people, if there's a divorce and we could prove that the marriage was bona fide at inception, it ended in divorce, we could still get the conditional green card removed. The condition and the green card removed. It could be removed. Not going to be a difficult situation if you have evidence to substantiate that your marriage was bona fide. If you have evidence to substantiate that you suffer abuse during the marriage, you could always also remove the condition without your spouse. Your spouse passed away, that one, we still have to show that the marriage was bona fide. Remember, those situations require proof that the marriage was bona fide, and that's why we need evidence to substantiate that the marriage was bona fide. The only time we waive the issue of a bona fide marriage is if a deportation would be a hardship to you, an extreme hardship to you. But that requires substantial evidence. It could be a fraudulent marriage, but we need to show and document that the marriage was entered into legally. It was a bona fide marriage, and when we talk about a bona fide marriage, what we are talking about is that you intended to share your life together. Now, there are situations when individuals never resided together, and these present difficult circumstances because one has to explore why. What happened? Is it the nature of your marriage? Is it a cultural thing? And one needs to provide evidence. All of those require detailed affidavit explaining the facts and circumstances of your situation. Remember, immigration is fact dependent, and one person's situation could be totally different. Yes, both of you are applying to remove the condition, but at the end of the day, their circumstance in their marriage could be and may well be different from your circumstance in your marriage. So one have to understand that. So when you say, and people call me all the time, they talk to me in consultations, and they say, well, my friend had that same situation and he ended up in deportation, etc. Why would things be different for me? And my response is, let's look at your facts. Let's look at the circumstance of your case. Your option is either you don't remove your condition and then you're still going to be in the same situation. It will be terminated by USCIS. You'll get a letter terminating that conditional residence, and you will be placed in removal, and it will be a difficult situation. You always need to file. You got to file by the deadline, and it's best. You could file after the 2 years, but we need to provide documentary evidence as to why we're filing the removal of condition late. So you file to remove your condition, and maybe you file jointly with your spouse. You went to the interview, you provide documentation, they will request for evidence, you responded to the request for evidence, then you get a letter saying, denied, and that your conditional residence is revoked, you're not in legal status. You could refile to remove the condition before the immigration judge. You'll get a notice to appear, which means that you're being placed in removal. So you eventually get a notice of hearing from the immigration court asking you to appear for a master calendar hearing. People get really nervous. They're concerned. Yes, it's removal. If the judge does not remove your condition, and you have an option to remove your condition before the immigration judge and to apply for any other appropriate relief before the immigration judge so that you could stay in the United States, people are nervous. Well, we could always refile. If you file jointly and there was a decision, and the decision was on the merits, meaning that no one withdrew that petition, your wife or your husband, whoever is the U.S. citizen, did not withdraw their support for the 751, and there's a decision on the merits, that means you could now file for a waiver. Because you filed jointly, you could now request a waiver, but you have to be divorced. So if you're divorced or there's one of the other criteria, you could apply to remove the condition while you're in immigration court. Remember, the application, if you're filing for a waiver for the first time, it has to be filed before USCIS. They have the jurisdiction to make a determination. First, if you're doing a new petition to remove the condition based on a waiver, if initially you file a petition jointly. But there are some technical issues. If the determination was on the merits, you went to the interview. If you went to the interview there was a determination on the marriage that the marriage was not bona fide, before the immigration judge, you could ask the immigration judge and your lawyer, and you should have a lawyer. Anytime you're in immigration court, you definitely should have a lawyer. Then what would happen is that your lawyer would file before the court asking the judge to review the denial. So you could go through, you and your spouse, if you guys file jointly, could go before the immigration judge at a subsequent hearing, individual hearing, and prove that your marriage was indeed bona fide, and the immigration judge could remove your condition and give you the 10-year card. The situation where one person withdraw the petition, if that happens, then you could file a new petition before the immigration court, and also USCIS to consider a waiver. And you go through the process. If USCIS first approve the waiver, then you will get the card, and then we could terminate your removal. If it's denied, the immigration judge could review that denial, and you could prove your case. If you could prove your case before the immigration judge, you will indeed get the 10-year card, and you'll be fine. So there are process and procedures in place. There's another situation, and a total different situation, obviously, if the immigration judge denies removal of condition. If it's denied, then, and you are married to someone else, and there's no fraud involved in the prior application or marriage, then you could seek to adjust your status before the immigration judge. Now, a lot of people call and they file to remove the condition, it was denied, or a spouse withdraw it, and years have passed, and they think they're undocumented. Technically, if it was denied, your removal of condition was denied, until the immigration judge order you deported, you're still you're still a conditional resident in the country. You could get a stamp in your passport, you could get your driver's license, and you could work. So you need to understand that. So a lot of people, and they come to me years later, I say, what have you been doing all those years? I say, well, my condition was denied, my card expired, I cannot get a license, I don't have any papers. I said, no, you're still a conditional resident, even though it was denied by USCIS. We could get a stamp for you in your passport so that you could work, and you could do what other conditional residents do in the United States, live a normal life until the issue come up before the immigration court. Eventually, you will be placed in removal, and a lot of old cases come up now with a number of individuals being placed in removal now after years, because the enforcement was not that strong at that time. Now, there's an emphasis on enforcement, so those of you who have your condition removed or removal denied several years ago will now get a notice to appear before an immigration judge. And that is always threatening to individuals when they have to go to immigration court. Now, I have a question for Anne. She asks, after 3 years of marriage, can I apply for citizenship before my condition removed? Already have a 1-year extension. So what Anne did is that she timely filed to remove the condition. She get the automatic 1-year extension of her card. She's still a resident. It's now 3 years because she's still married to the U.S. citizen. And the issue is, could she apply for naturalization? The answer is yes, you could apply for naturalization. Your removal of condition is pending. What will be done in those cases is that the removal of condition will be adjudicated first before a determination on naturalization. And that's a means for a lot of individuals to force USCIS to make a decision. They file application for naturalization. So yes, that is possible. Once you have the 3 years, your application is pending, you can do that. And there's a question from Donna asking, when can I file for citizenship? My spouse is dead. If your spouse has died and 5 years. The issue is 5 years. In that case, if it's a U.S. citizen spouse, normally you could apply for the 3-year statute applies to you. But if your spouse has passed away, you're going to have the cap for 5 years in those situations in order to apply for naturalization. Here I have a question from Alik, Ekileh. Her mother applied to adjust her status. She's married to a citizen. They went to an interview. 3 months has passed, and she wanted to know what's going on. It's pending. A decision on the adjustment application is pending. When a decision is made, she will be notified. Generally, you want to wait about 120 days before doing an info pass. They could always do an info pass and go in to check in, or have the attorney do it. Most people have lawyers, and these are things the lawyer should be doing for them. After 120 days, your application is still pending. You may want to do an info pass. Calling the 800 number generally not going to help, because your case is at the local service center. It is not at the national center. They may send an email to the local service center, but you could always do an info pass and go in, try to figure out what's the status of your application. I had some questions, and one of the questions I get from a number of individuals, even before we go live today, was, I have a conditional green card. We never reside together. She was trying to help me. We went to the interview the first time. Everything went well. We got a conditional green card, but then we have our separate homes. And now I was told that she wanted a divorce because she meets someone else that she want to marry and file, or she's pregnant. And I get the variation of those sometimes, that the person is pregnant, have a child, and now they want to move on. What can I do? Generally, when I get those situations, when those situations come up, most lawyers, and you explain it to most lawyers, they look at this as a fraudulent marriage. Because if you pay someone to marry you, under the law, that's a fraudulent marriage. If you never reside with your spouse, or your intent was just to get the green card and you pretended, that is also marital fraud. Those individuals are going to have tough time really proving that the marriage was bona fide. If they do not have substantial evidence together or sharing their lives together, that's going to be a difficult situation. Most lawyers may not want to promote fraud. So if you outline to a lawyer that you engage in a fraudulent marriage, most lawyers will not want to advance that case for you. And so because it's against the law. And one of the functions of most lawyers is not to perpetrate a fraud on any tribunal. If we know something is fraudulent, we, in good conscience and faith and ethically, we cannot advance a fraud. And marriage fraud is one of the situations that is very prevalent, and most lawyers in a consultation try to understand the nature of the marriage. Sometimes people are married, and they married in good faith, and then things fall apart. That is a normal situation. That is not fraud. If the intent at the time that you enter into the marriage was to share your life together, and it didn't work out for whatever reason, then it's not fraud. You may not have much evidence, and one will do their best to gather as many affidavits as possible, but it is not fraud. The fraud only comes if you paid someone to marry you, or there's some kind of consideration, and it was solely for immigration purpose, to help the person, to help them stay here, to help them stay with their kids, and it have nothing to do with consideration or sharing your life together. Now, there are always mixed motives for marrying. Sure, if you're undocumented in the United States, you meet someone, you meet a citizen, you may want to marry the person, but because there is that side benefit, and it's a side benefit of adjusting your status. It just cannot be the sole purpose. And a lot of people do that. They marry to a U.S. citizen, and then they move out. They go to another state to work, and they say, well, I need to work. I cannot say I couldn't find employment locally. I had to leave. And maybe they may see each other once a month, every couple of months. That's always problematic for immigration, because if you marry someone, and remember, immigration cannot get into your head and know the intent. We look, lawyers and individuals, on the way you behave, your circumstance, because marriage should not be taken lightly, and they believe you should be sharing your life with that person. Sure, people could come to a determination based on their circumstance of their family situation that we need employment, but if you work in far out of town, in far out state, and the income that you generate does not, if not substantial enough to even supplement what you could make locally and supplement your life locally, then the issue bears on intent, that you only wanted to marry so you could get a working paper so you could just work. So all of those things need to be taken into consideration, and you really have to think of it, look at your circumstance and look at your situation and make a determination how a reasonable person looking at that will decide your case, because that's what they're going to look at. They're looking at your circumstance and making a judgment on what you do. And is it reasonable? Is that love? Is that a relationship? Is that what you guys really, when you say you're married, was that what you intended at the time that you move off to a different state and you never visit, the person never visits you? I mean, if you're maintaining that relationship and both individuals are visiting each other, that presents a different case. So it's always important to look at your circumstance and, you know, make a determination what's going on, how would someone look at it, how would immigration look at it, and that's why it's always good to have an immigration attorney who's going to say, do we have some issues, you need to get this, you need to provide those documentation, that documentation, because that will help your case. Just filing your application by itself is never going to work for a lot of individuals. It's just never going to work. Now, I have a question. What evidence do you need to provide during the initial application process, interview, and subsequent removal of green card? Obviously, I'm not going to sit here and go through and tell you what you need to provide, but if you're married, there's just natural documentation you are going to have. You have to share your life together, you know. And a lot of times, documents are not necessarily that important, but the expression of answering the questions appropriately. Most individuals may have a lease together. They reside somewhere, so either someone owns the home or they're renting. And if you're renting, is it jointly or not? There are changes of name situation. There's just what people normally do during a marriage. Do they save money together? They share their expenses together? So you will need evidence to establish those. Photos. A lot of people talk about photos. Well, you do not have to bring photos. It is not required, but if you do provide photos, your photos should help. And the vast majority of immigrants provide photos that does not help their case. It detracts from their case. It looks like a stage. So people supply photos, and they come to me with photos a lot of time, showing they and their spouse sitting together at home. No one takes photos, generally, of you and your spouse sitting together at home, lying down in bed, kissing. Who does that? No one do. So providing that it's just a clue to immigration that this is staged. You are staging a marriage, you are staging a relationship. So all of those are useless, and it's not going to help you. It's going to create more problems. So in terms of documents, and people ask me what kind of questions they ask, they're not going to ask you any other question that you as a married person in your circumstance cannot answer. They're going to ask you about your own relationship. They're going to, and it varies. It could be anything. Sometimes there's no question at all. It all depends on the preparation of your application and the documentation of your application. So it is a feel. Yeah, you understand? It's a feel. Everyone look at desperation, and the more desperate you appear, obviously that's when people do a lot of stuff. Desperate people do things that are not normally right. You understand? Not normally in their best situation. So if you're here and you're desperate trying to get papers because you need to do this, you have been here, you haven't been working that much, obviously you are prone to making errors. cutting corners, prone to go into individuals that will just prep your application and give you a bunch of documents and affidavits that you don't even know those people. And they may ask you who are those people. When you go to your interview, they say, who's that person who wrote that application? What's the person's name? How you met the person? You are asked questions based on your application. What's in your file? And nothing else. If you say you reside at a location, they're going to ask you questions about that location. All of these are fair game. Anything on your application is fair game to explore. So, just bear that in mind when you're asking for documents and just looking for a list of documents. Some of the documents may not be necessarily appropriate in your situation and your case. So you have to look at your circumstance, your situation, and we provide documents and evidence that is appropriate to your circumstance and nothing more. I had some earlier questions that I would like to also touch on. Someone asked about old convictions, because even though you're removing your condition, if you have certain convictions, because they all apply, they are crime. Most crimes have immigration consequences, and we'll discuss that in a separate video, but I also want to touch on it because it applies. Because if you're trying to remove your condition and you have a marijuana conviction, you have drug trafficking conviction, you have certain fraud convictions, theft convictions, you're going to have problems. Because these are issues that are going to place you in removal. And once you're placed in removal on those, you're going to have to deal with that, and there's the issue about a waiver, whether you're eligible for a waiver. So the law does not say a conviction today. Most times it says based on what you're applying, whether you're applying for a green card or you're applying for naturalization or you're traveling. Those convictions say at any time. At any time. So it could be today, it could be 20 years ago, it could be 30 years ago. And I have dealt with individuals who are placed in removal today for offenses that happened 30 years ago, 1977, 1979, 1980. So that's what the law says. It's not a conviction yesterday. At any time. So immigration officials look at the statute, and if the statute defines an offense that you commit at any time would make you inadmissible to the country or make you deportable from the United States, you will be subjected to that provision of the law and nothing else. So saying that a conviction occurred 50 years ago, 20 years ago, 10 years ago, generally is not a defense. It has the same consequences just based on the law. And we just applied the law to your current circumstance and nothing else. So certain convictions will certainly have issues in removing the condition, in getting the green card. If you leave the country and trying to come back into the United States, those convictions may have problems for you. There are certain convictions that if you do not leave the United States, you are fine. You could apply for naturalization. But there are those that if you ever leave the United States and you're coming back, no, you're going to be placed in removal because it would make you inadmissible into the country. And when they place you in removal on an offense that make you inadmissible, they're saying you should be excluded from the United States. That's what they're saying. You should be excluded. Your departure from the United States place you in a situation where you're now applying to be admitted, even though you have a green card. Green card does not guarantee admission, just as a visa does not guarantee you're going to be admitted into the United States. The inspector, the CBP officer, will determine whether you are admissible, and that's why your entire situation is reviewed to make a determination whether you are now admissible once you depart the United States, whether you are now admissible into the country. So these are issues that you need to understand. And I know a lot of people say, oh, these are old conviction. A lot of people get caught up into, oh, I traveled about 5 times before and nothing happened. And now the 6th time it will, you have an issue. The reason for that is this simple. Immigration is generally USCIS, CBP, ICE are refining their computer system. Now, the convictions that you may have had that was not updated into the system, it may be updated. So when you traveled before, they swipe your card, nothing was there. but since your last travel, it may have been updated, and now you travel this time and you have an issue. So always understand those things, because it's always going to be an issue for you. Do not get comfortable in the fact that nothing has happened before. If you have a conviction, or you've been arrested for certain offenses, before you travel, contact an immigration attorney, consult an immigration attorney, and let them look at the conviction and make a determination what issues that you may face. The mere fact that you have traveled before is not really a defense. I have a question from Remy. I'm on an F1 visa and I married a U.S. citizen and I stopped going to school. Can I file for adjustment of status? Well, if you're eligible, and since you came in on an F1, you were admitted and inspected, you're married to a citizen, you could apply to adjust your status. Now, there's also an issue whether when you apply for the student visa, you committed fraud. So, because a lot of people sometimes, when they apply for student visas, they may not have enough funds, because one of the things you have to prove in order to get a student visa is that you have sufficient funds to pay for school. And individuals may not have the funds. They may have asked a group of people to maybe deposit money in their accounts, etc. And, or they create fraudulent bank records or statements, etc. And they get the visa. So now you're applying to adjust. All of that is evaluated. I just want you to understand, when you apply for adjustment of status, your entire immigration file is considered from the date you apply for the visa to current. So anything that happened along the line, if it could be viewed as fraud or misrepresentation, you're going to have an issue. You may need a waiver. So in those cases, for adjustment of status, marriage-based, a green card, I always tell everyone, before you file, consult an experienced immigration attorney. And the person should be licensed. That means member of a state bar in good order. And that is your best safety net to ensure that if there are problems, because not every, there are going to be some issues sometime, but at least it is known and a plan is thought of at the beginning to combat that situation. So it's not a surprise, because your lawyer would be prepared. You would be prepared for those circumstances and those issues, so you could address the issues. It's always best to be prepared. An unprepared person, obviously, they have the most issues and the most problem. And you should really be honest with your lawyer. So if you retain a lawyer, you consult a lawyer, you want the best advice you could get. And remember, the advice is only based on what you say, on what you reveal. So if you do not reveal the complete truth, it's going to be difficult to give you the best advice. You get advice based on what you said, and therefore you left out certain facts, and those facts were not considered in the advice. And if it was not considered, it is revealed, you have an issue. So if you have a conviction in Canada, and you don't tell your lawyer, immigration will find out. And you will have the issue. So if your lawyer knew about it, they could have gotten the record and say, listen, this is going to be a problem. It's going to place you in a worse situation. Maybe there's no waiver. You will be deported. But if you do not reveal it because you're desperate, you're looking just to want to get the card and you're just looking for an advice, say, yes, do it, file it. That's going to be a problem for you. I have a question for Vinny. Asks, can a U.S. citizen who is married to a foreign national and residing with his wife in that foreign country, can that U.S. citizen still apply for U.S. citizenship for the wife and the kids? Well, first of all, Vinny, I just want you to understand, if you're a citizen and you're applying for a spouse, you're not applying for citizenship for that spouse. You're applying for a permanent residency, which is a green card for that spouse. That's what you're applying for. And permanent residency is for the spouse to reside with you in the United States. So if you're residing outside the country, you're not in the U.S. military. If you're in the U.S. military, only working for the U.S. government outside the country, that's not a problem. You're still considered in the United States. So If you're outside the country, you're not working for the U.S. government or any of the agencies and international organizations that the U.S. is part of, then the law says you cannot file for your spouse. You cannot file for permanent residency in the United States for your spouse because a spouse is not coming to reside with you. A green card is not a tourist visa. So it is not citizenship you're applying for residency. You're filing for an immigrant petition for your spouse to join you in the United States to reside. With the green card, after 3 years or 5 years, depending, that person, your spouse, could apply for naturalization, which is citizenship. You're not applying for naturalization or citizenship for them. It's different as it relates to kids, but you're talking about a spouse. So, no, if you're outside the country, you cannot do that. You could file what you want, but it's not going to be successful. Obviously, if you file the application, USCIS is going to process your application, process your fee, and at the interview, you will be told no. And you're going to say, how come, why didn't you tell me that at the beginning? No, that's not the duty. You file. You should know the rules. So consult a lawyer. Always do that before. Janet asks, my brother was living with a young lady and they got married and she filed for him. She was told by her friend to withdraw the filing, saying he's going to leave her when he gets his papers. What can he do in a situation like that? There's nothing he could do. Remember from my last video, on marriage-based green cards, that it's the U.S. citizen or the resident prerogative to file for a spouse. They have to support, once they file, they have to support the petition. If they withdraw the petition, it is withdrawn. Your brother, the non-resident, cannot get a green card just because he's married to a citizen. The citizen have to support that petition all the way through. So if it's withdrawn, it's withdrawn. Obviously, they need to work on their marriage. She should not be, obviously, if their marriage is good, she should not be listening to other folks. Apparently, there may be some issues in the marriage, and your brother and her need to work it out. But once it's withdrawn, it's withdrawn. You know, he cannot take it up on his own, continue it. He required a U.S. citizen to do that. Deandra asked, and I'm going to respond, Deandra. I'm in my final year as an F1 student, and I've applied for a work permit, and I'm waiting for it. I'd like to stay after I'm finished with my vet tech degree, but I'm confused as to how to plan. I know about the marriage and employment, but I have been unsuccessful in both cases. Any advice? Well, obviously, I would say one thing. Most lawyers never tell people whether to marry or not marry. That's not them. They advise you on the law. So you plan in your life, you'd like to stay in the United States after you finish school, you complete your OPT program. The only way to get a green card, and I've emphasized that, the ways you need a family-based petition, employer-based petition, you could self-petition, or if there's asylum and you have asylum for a year. But family-based include marriage. So all of that going to based on your circumstance. If that's your situation, that's your situation. If you do not fit into any criteria, that's it. You know. So you have to fit within one of those criteria. So if you you're not in one of those criteria, it would be difficult for you to get residency in the United States. The OPT program is a work program that individual who study here in non-technical, non-vocational program get OPT. They allow them to work in the United States for a year. They get a work permit for a year. It's part of the training, practical training. It's called occupational practical training program. You could apply for that with the assistance of your school. They have to certify that it would be helpful for you, and you get a work permit for a year, so you could work here for a year. After the year is over, for individual in STEM program, it's longer than a year. And that's really what it is. So when I say OPT program, students may know about it, but most other individuals may not know. But it's a work permit that you could stay here and work to obtain some practical training in your field. Gordon asked, my wife is a green card holder. She's from the Commonwealth of Dominica, but received a card as a resident of Paris, France. At first, she was told that she should not stay out of the U.S. for more than 1 year, so she took her time to make the move by spending time in the U.S. at least 3 times a year. The last time she entered the U.S., less than a month ago, she was advised to get some special permission from the authorities that would give her 2 years of free travel in and out. Yes, a green card holder must reside in the U.S. A green card is not a visitor visa. It is not for you to visit the U.S. It's for you to reside. If you do not comply with the residency requirement, you could have been deemed to have abandoned your residency, and therefore the card is terminated. So if you want to stay outside the country for 2 years, one could apply for a travel document. You may want to talk to your immigration attorney, or you may want to call my office for assistance there. The office number is 407-295-0099. So, but remember, a green card is to reside in the United States. It is not for, visiting the United States. You should reside in the U.S. more than you reside outside the country. Never want to stay more than 6 months outside the United States. So it's important to know that and to comply with the requirements, because if you don't, you're going to have serious problem. Now, follow-up question: if the person took too long to send in a document, they asked for and they denied the application because of that, they said they should refile the application, will the person have to pay? Yes. Remember, if you file your application and a decision is made on your application, then if you file to reopen your case and explain the grounds for reopening, and the case is reopened, then you do not have to pay the fee. But an application, a 290B, to reopen your case is going to cost you. There's a filing fee for a 290B. But if you refile your application, you file in a new set of application, you have to comply with all the fee requirements. If you do not send the fee, it will be sent back. Okay? So understand that. So that's one thing that one should understand, that every application, every filing, there's a filing fee. If a decision is made on your application, it is made, so that's the situation, and that's where we are as it relates to that. A few things that one should consider in removing condition. I want to get removing condition. From the day that you obtain the green card, you need to gather as much document, from that day going forward to the day that you apply to remove your condition. Anything that you guys buy jointly, keep a receipt. Every vacation trips that you guys have, take photos of it, document that. If you buy a house, you rent a new place, always have joint 2 of you on that lease. It's important to do that. For any special occasions, take as many photos, but special occasions with people involved, because that means you're broadcasting you're married. If you're married and truly married to someone and you're going out, you have a party, it's Christmas, it's Thanksgiving, people take photos. It shows that you're declaring, this is my spouse. You're bringing the person among your family and your friends. So you need to have those documentation. Everything that you do, it needs to be documented because immigration want the documents. That's the only way they could make a credible decision. That's the way the officer going to feel comfortable about the marriage. If you have evidence that you are declaring to the world that that person is your spouse. If you're keeping the person a secret, that's not to them, not legitimate. It's not bona fide. So you have Facebook page, you have or the social media page, and the person is nowhere on your page. There's no mention of your marriage on either one of your pages. And immigration do check social media, and that's what people use nowadays, and they do check to make a determination. So if you legitimately are married, there should be no secrets there. Because if there's no secret, the officer feels comfortable that your marriage is a legitimate marriage, and your case could be approved. So, but when there are secrets, that creates doubt. And when there's doubt, there are investigations. And investigation may uncover stuff that casts more doubt on the marriage. It may not be conclusive that your marriage is not bona fide, but it casts some doubts on it. And when there's doubts, it takes longer. There are investigation, and you will be waiting. And if the doubts are not overcome, you will get a denial. And then once you get the denial, you may need to face reapplying, moving to reopen with additional evidence, and those feeds on themselves. So the earlier you could get things done, the quicker you could get it done, the better it is. I have a follow-up question here that I would like to address. For Deandra, you mentioned two things in your response to my earlier question that I had not heard of. Filing for myself being one, and an extension for students in STEM program. Do you mind elaborating? Well, one could always file a self-petition. That means, but you can't just file a self-petition. You have to meet the criteria for self-petition. So if you're in a highly specialized and skilled area, then obviously you could see if you meet that standard and apply for the immigrant petition based as a highly skilled or specialized individual. So that's one area. The STEM program has an additional length of time. The OPT program is longer for STEM. So when I say about a STEM program, it's just if you apply for OPT and you're in a STEM program, you'll get the longer STEM time. So if you have just gotten 1 year, most likely you do not fit it within the STEM program. So that's really the situation. And there's the extension too. So if you're in a STEM, and you could maybe get an extension also. But these are your circumstances, Andrea. And these are the way, but it's wise. It's always wise, I tell individual, to consult an immigration attorney. Not an individual who fill out application for individuals, a consultant. A consultant is not a lawyer. People call themselves a consultant, and people trick me a lot of time. Oh, I use an immigration consultant. I say, who's that? What makes the person a consultant? What, they just put a business card or have a shingle saying, I'm a consultant? I mean, understand that. If the person cannot accompany you at your immigration interview, that person is not a lawyer, period. If the person could accompany you at your interview, then that's different. But you could always know whether the person is a licensed attorney or not by just checking the state by where the person say that he or she received a license from to practice. So, because there's a lot of bad advice going on, tons of different advice. Obviously, lawyers may have different take on it. Some lawyers may be more risky than other lawyers in terms of, and some may be more aggressive than other lawyers. And that's all good, that's all fine. These are normal circumstances. But the issue then is whether the person know what they're doing and could accompany you to back up what they say. And if the person cannot accompany you to back up what they say, they could say anything. And a lot of times people give folks documents to take in, and the document does not even apply to their case. So always do your due diligence. It is good to get help, seek out help, but always get the best help that you can, and be wise from whom you take immigration advice, because that's your life. You're in the United States, you have maybe invested a lot of time, you have sacrificed to come here, and maybe forego a lot of opportunities in your country or another country to be here. And you want to make the best decision for you. You want it to be your home. And if you want it to be your home, you just got to do the right thing for your own self. This is immigration attorney Peter Loblack. It was a great Saturday, great conversation with you. I will talk to you next Saturday. If you want to schedule a consultation with me, you could call my office. The telephone number 407-295-0099. You have a great Saturday and a wonderful weekend.